hopefully everybody can see this screen. Just a little bit about myself. I am a lawyer in Yellowknife. I've lived here for about 7 years, and I have a practice in wills and estates, family law, child protection, and Indigenous law. So I do a little bit of a lot, but I am really focusing my practice on wills and estates practice. This presentation will focus on estate administration in the Northwest Territories. I've done presentations in the past on wills as well, and now this is kind of the second part. So what happens if you have a will? What happens if you don't have a will and one of your loved ones has passed away? Sorry, I'm just trying to move on to the next screen. So in this presentation, we're going to cover what the definition of an estate is. We use that term a lot, but I think it's really important for us to define what that actually means. We'll talk about the different roles that people play. So we'll talk about what an executor is, what an administrator is. We'll also talk about the role of a lawyer in estate administration, the role of the public trustee, as well as Saranac. We're going to discuss some of the estate administration roles in the Northwest Territories as well. We'll talk briefly about the steps and duties of an executor or an administrator. We'll talk about what happens when someone passes away without a will, which is called intestacy. And we'll also talk about some best practices if you are an executor or an administrator for an estate. So what is an estate? So anyone who owns something has an estate. An estate can include any real property, such as lands, buildings, or structures, and any personal property. And this is everything that somebody owns or had in their possession when they died. Examples of some of these things are homes, cars, quads, snowmobiles, RVs, bank accounts, stocks, bonds, mutual funds, business interests, furniture, clothes, any ceremonial items, traditional items, guns, jewelry, artwork, collections, work benefits, earnings such as your last pay, proceeds from legal actions or class actions, and proceeds from any other legal actions, CPP, and etc. So we do know that when people were making claims to their residential and day home class actions, that some people who had already passed away were going to be receiving that money. And so those monies are and form part of an estate as well. So any legal action proceeds awarded in that are asserted either before or after the death form a part of the deceased's estates. So this could include things like motor vehicle accident claims, wrongful death, and as I mentioned, any class action settlements. So CPP benefits also are and can be a part of an estate because the Canada Pension Plan provides contributors' families with survivors' death and children's benefits. The deceased's dependents, such as their widow or any minor children, might be eligible to receive a benefit from CPP, and the estate might also be eligible to receive some sort of death benefit, which could form a part of the estate. So basically, anyone who owns something has an estate and can include a lot of different types of assets. Debts also form a part of an estate. We'll talk about debts a little later in the presentation, but I did want to flag for everybody that it's about what you own and what you owe on the date of your passing. So there are certain items that are not usually part of the estate. So typically joint bank accounts and any property held in joint tenancy is not a part of the estate typically. Those items typically pass by right of survivorship, which means they go directly to the other person who's named. So if you have a joint account with your spouse, when you pass away, that joint account by right of survivorship would go to the person, your spouse. Sometimes bonds and investments such as RRSPs, TFSAs, and RRIFs do not form part of the estate. This is typically when there's a beneficiary listed, and life insurance proceeds sometimes are not part of the estate. And again, that's where a beneficiary is specifically named in the policy. then the proceeds of that policy are not part of the estate. But if there is no beneficiary name, then the proceeds of the policy do form a part of the deceased's estate. So now that we've gone over some of these definitions, I'm going to talk a little bit about the different types of roles that everybody has. I know a lot of people, think a lawyer will administer the entire estate in the same way that the public trustee does, or they think Cernak will help. There can be a lot of confusion with all these different parties involved. So I just want to clear up some of those definitions and the different roles that people have when an estate is involved or when you're administering an estate. So first and foremost, we're going to talk about an executor and an administrator. So an executor is somebody who's named in the will to manage the estate. An administrator is appointed by the court, typically in cases where there's no will or it's disputed who should actually administer the estate. So the most fundamental principle of estate law is that the executors or administrators are trustees. They receive the estate from the deceased person and administer it and distribute the estate for the benefit of the beneficiaries. So they take the estate and they hold it for the benefit of beneficiaries, for other people. An executor can also be a beneficiary, so they might be holding an asset or holding items in an estate for their own benefit as well as the benefit of other people. So, sorry, I skipped a little too ahead, but an administrator, again, is somebody who is appointed by the court, and there is an order of priority as to who can be the administrator. So if somebody passes away without a will, there is an order of priority as to who can apply to the court to become the administrator. So typically that's the spouse who survives them first, then it would be a child of the deceased person, then a grandchild, then any other issue other than the child or grandchild, then the parent, then the brother and sister, and so on forth. So there is an order of priority and you can't just skip. If you have a spouse that survives, a child can't just come and try to be the administrator. That first person on the list has to sign some documents such as a renunciation to say that, okay, the person ahead of me on the list doesn't want to be the administrator. They've signed this document, and so therefore I can now apply to be the administrator. The executor or the administrator can be someone who lives outside of the Northwest Territories, but there might be special requirements such as obtaining a bond or requesting that the bond requirement be waived. So again, somebody who doesn't live here can be your executor or can be the administrator of an estate, but there might be some special requirements about a bond. So a lawyer is a professional who's retained to guide the executor or administrator to draft court documents and advise on complex issues. Lawyers can be used to draft the probate documents, which we'll talk about later, or can be involved in more complex estates, and any disputes that might arise. So of course, the benefit of hiring a lawyer to assist you with that is that they have expertise in this area. But of course, they can be costly. And ultimately, they must be supervised by you as the executor, because it's your ultimate responsibility to supervise them and to administer the estate appropriately. So from my experience, many lawyers in the Northwest Territories won't administer the estate for you, but they'll assist you in applying to the court for a probate or administration. So the lawyer isn't the one that's going to collect all the assets or secure them or even distribute them to the beneficiaries. But they might be the person who's they may, but are likely not going to be the person who's primarily responsible to be the executor or administrator of the estate. They can help you as the administrator or executor, but they're not necessarily going to take on all the jobs or responsibilities of being an administrator or executor. The public trustee is a statutory office that can act as administrator of estates, especially where no one will or can under the Public Trustee Act. They'll only generally accept administration where the only beneficiaries are children under 19. the beneficiary is a spouse and a senior citizen over the age of 65, or the beneficiary is mentally incapable, or there are significant assets and no next of kin can be found. So in the case of a public trustee, they are the executor, the administrator of the estate. But they have a very stringent criteria on who they will accept files for. There are also fees involved with having the public trustee involved. And also the process can be slow to administer the estate, given that they might have a significant backlog. So unlike a lawyer, the public trustee is the estate administrator. And I think there is some confusion in the territory with respect to their role and the role of a lawyer who you hire to help you in executing your duties and responsibilities as an administrator or executor. So sometimes CERNAC can be involved as well, because under the Indian Act, they can help in administering estates for people who are ordinarily resident on a reserve. Ordinarily resident on a reserve means that an eligible First Nations person usually lives on the reserve and does not maintain a primary residence off a reserve. Many people in the Northwest Territories will not fall under this definition, although we do have 2 reserves, so there may be some individuals who can get assistance from CERNAC in applying for estate to be the estate executor or the estate administrator. Similar to a lawyer, CERNAC is not the administrator. It's still the job of the executor or administrator to administer the estate. The CERNAC won't do that. They'll maybe help you with the court paperwork that's required, but they're not going to be the one collecting all the information on your assets or the debts or distributing it to the beneficiaries. That job ultimately lies with the executor or administrator of the estate. So in the Northwest Territories, there are different pieces of legislation at play, and that's especially the case in complicated matters. So the estate administration rules govern the probate and administration process. The Intestate Succession Act contains rules when there is no will in place. The Public Trustee Act discusses the role of the public trustee. The Wills Act discusses the requirement for a valid will. The Indian Act discusses estates of Indians ordinary living on reserve. And then there's, in complicated matters, the Family Law Act that's involved and the Dependents Relief Act that's involved. So if there are multiple spouses, maybe the Family Law Act will come into play. If a spouse doesn't feel that they were properly accounted for in the will, then they could make specific elections under the Family Law Act to have a different type of distribution of the estate. And same for dependents. If somebody passes away and they have dependents, so minor children, children with disabilities, or even spouses, then those people could also make a claim against the estate. So again, it could be really important for you to consult with a lawyer, especially when the estate is really complicated and these other issues arise. There are also Indigenous laws and different rules around where you live, how land is held, etc., that may be applicable when you're administering an estate. So you might have to consult your local governments or your local band with respect to how to distribute the estates. There might be, there are a lot of different laws related to land and property on Indigenous lands. So you may have to check with your First Nation or band or self-government on what it looks like. If you own your land, if you have a leasehold interest in your land, who it can be transferred to after you pass away, etc. So there is a lot of different types of legal frameworks in the Northwest Territories, and it can be really confusing. So it is important to consult with a lawyer, especially if you have a complicated estate. All right, so you're the executor or the administrator, what do you do? So these are the steps that an executor or an administrator usually takes. Once appointed, an administrator or executor is entirely responsible for the administration of the estate, and they are accountable to the heirs and the beneficiaries of the estate. So over the course of the administration of the estate, the administrator or the executor has a really, really big job. They do it all, really. They will be required to do these steps. So first is obtain a death certificate and to locate the will. The second is to secure assets and to identify the beneficiaries and heirs. Third is to inventory and get valuations for some of the assets. Then would be to apply for probate and administration. And usually that person hires a lawyer to assist them with that aspect. They may also need to advertise for creditors and pay off any debts and taxes that the deceased person had on the date that they passed. Then ultimately they're responsible for distributing the remaining assets of the estate and then closing the estate. We're going to talk about each of these steps one by one so that we have a clear picture. This is just kind of an overview of some of the big responsibilities that the executor or administrator has when they administer an estate. So the first one is pretty straightforward. The executor or administrator has to get the death certificate from Vital Statistics. This is not the same document as the funeral director's statement of death. While the funeral director's statement of death can be helpful initially, typically you need the death certificate from Vital Statistics. You can apply for that online now, or through fax, and I believe through email. I think Vital Statistics and Health and Social Services can help you in obtaining that death certificate. A lawyer, if you've hired one, can also assist you with that. The next thing that an executor has to do, or an administrator or an heir has to do, is locate the will. They should check through the deceased person's records, safety deposit box, gun safes, desks, filing cabinet, or any other property owned by the deceased, such as their cabin, to try and locate the will. They can also ask around to see if another lawyer may have their will or if another family member may have their will. It's really important that you document your search efforts and if you have the documentation to provide to the court. If the will can't be found, but a copy is found, the executor could possibly apply to the court to have the court recognize the copy of the will as the valid last will and testament. The court would have to review evidence from family, friends, and professionals and decide whether the copy can be accepted or not, but it may be possible. You should also remember to check for holographic wills, which are wills written entirely in the handwriting of the deceased person. So it doesn't necessarily have to be typed. You should also look for those documents in the deceased person's important records. You can also advertise through the appropriate law society when you're trying to locate the will. If you think, oh, I know that they were dealing with this lawyer, they might have the will, you could reach out to the law society and see about them advertising in their newsletter to determine if somebody in the territory has that, if a lawyer in the territory has that will. So again, it's really important you try to locate the will and document your research, your search efforts. So the next thing that an executor or administrator has to do is secure the assets of the estate. Usually, when you tell a bank a person has passed away, they'll freeze the bank accounts. So it can be helpful to open a new bank account called an estate bank account, which will only be used for estate matters. Such an account will allow the administrator to write checks and keep track of all the deposits and payments made when dealing with the estate. And it'll also be helpful because then you can distribute directly from that estate account and then you'd be able to close that estate bank account. It's really important for you to be able to keep accurate and detailed records of all the transactions to satisfy the beneficiaries. So it can be really important to open an estate bank account right away to secure the assets like GICs, money, savings, etc. Usually banks in the Northwest Territories ask that you get a grant of administration or probate before they'll let you open this type of account, but not always. In the southern jurisdictions, they let you open that account if you have a will and a death certificate. But up here, I've noticed definitely that they want you to have that court order, that court grant before they'll let you open that account. You'll also want to make sure that the assets are secured by having appropriate insurance. So, for example, making sure that the house insurance is renewed, car insurance is renewed, keep up with any insurances for any cars, boats, any livestock. You also just need to ensure that those valuable and vulnerable parts of the estate are cared for. So you might want to keep up with ensuring the building is maintained and that any animals or livestock are cared for as well. So you just want to make sure that you secure the valuables that are inside or outside the home or any other buildings that the deceased person might have had, including any cabins or any containers that they might have on their property. If a deceased person owned a business, it might be really important for you to arrange for the ongoing management of that business by hiring any professionals or dealing with that yourself if you're also part of the business. It's really important to secure the assets because you don't want to lose track of them. I know that sometimes a lot of fighting can happen between siblings, going in and out of the house, taking stuff that they might not necessarily or should be taking. So it could be important to, change the locks, limit who can access those buildings and the items within those buildings, because ultimately it is your job to secure the assets of the estate when you are the administrator or executor of the estate. You also just want to make sure that the home and assets are protected from the elements and maintained properly. So, in our jurisdiction, living up north, you want to make sure, the pipes don't freeze, for example. Or if a plumbing issue arises, that you deal with it instead of it becoming a bigger issue or a bigger leak, and then it significantly deteriorates the property and the property loses value. If there are tenants or renters in that property, you also want to maximize income from that property and keep account of it accordingly in the estate bank account. You'll also need to identify who the beneficiaries and heirs are of the property. So you'll need to know who are the ultimate people who are going to be receiving some of these assets. You should check the will first and foremost to identify who the beneficiaries of the estate are. And if there is no will, then you will need to consult the Intestate Succession Act. A lawyer can help you consult that, but generally some of the beneficiaries that can be easily identified are spouse, children, parents, siblings, and etc. There is an order of priority as to who will receive what. And a spouse is typically the first person. So where the estate doesn't exceed $100,000, the spouse generally can elect to receive the first $100,000, or they can elect to receive the home if the value of the home is more than $100,000. If there is a spouse and one child, and the value of the estate is more than $100,000, then the spouse gets half and the other half goes to the surviving child. If there's a spouse and multiple children, then the calculation's a little bit different. 1/3 goes to the spouse and then the 2/3 is equally divided by the children. But if one child passes away during the lifetime of the deceased person, then it could go to their children. So if you don't have a will, it can get really complicated, and I won't get too far down into this, but I just want to point out that you need to identify who the beneficiaries are, check the will, and if there's no will, check the Intestate Succession Act, but keep in mind that generally spouses and children have some sort of priority. If there are no children and there are no spouses, then it would be the parents who survive the deceased person. So I think keeping those three at the forefront is a good idea for now, but your situation could, be different and you should consult with a lawyer on your specific situation. So the executor administrator also has to take an inventory and value some of the property. They need to create the list of assets and debts, and they might need to obtain valuations for items such as the home. So listing all the assets and debts means listing all of the personal effects, including paintings, jewelry, boats, cars, the contents of any safety deposit box, guns. They might also need to write to the banks and credit or financial institutions to ask for what might be in the bank account, how much money is in a savings account, if they have a GIC, etc. You'll also have to identify and secure all digital assets owned by the deceased person. You might need to write to insurance companies To get particulars of any insurance policies, you might need to write to the past employer to see if there's any last pay owing, any vacation payouts, any sick leave that needs to be paid out. You might also need to get in touch with any private or government pension programs to determine if there's any pension amounts owing, if there are any death benefits payable. You'll also need to probably fill out some forms with respect to those institutions. You'll have to collect any other money owed to the deceased, like salary, group benefits, etc. I think I just repeated myself, but there's a lot to do when you have to create this list of assets and debts. You also have to check with the banks or investment companies about RRSPs, RIFs, TFSAs that the deceased might have owned on the date of their passing. You might also need to do a title search to see what kind of property they owned on the date that they passed. Check any lease documents, check, for any mortgages. Check for any business interests if they own shares in any companies. You'll also need to determine what debts that person owed. So maybe they owe some credit card debts. Perhaps they owe the long-term care facility some money from where they were living, some property taxes. They might owe money to somebody individually. So it's really important that you create that list of assets and debts. The only way to really do that is by reviewing the deceased person's documents, their papers and their records, including any electronic records, and asking third parties about those records. So, the funeral home, you might want to reach out to them, see if there's any invoice outstanding, any medical expenses, lines of credits, etc. So you may want to reconsider being the administrator or the executor if you become aware that there are more debts than there are assets. You can still be the executor or the administrator if there are more debts than assets, but you may need to reach out to a company to determine if bankruptcy or debt consolidation is the right move for the estate. Okay, so then once you've collected that list of assets and debts, you know what that person owned, what that person owed, you would apply to the court for a grant of probate or administration. And this is typically where a lawyer becomes involved. So what is probate? What is administration? It's basically a court application and a process of proving that the will is valid. It's kind of like the green light on getting to be the executor. During this process, the beneficiaries and anybody else who might be entitled to share in the estate is given notice. So they're usually given a copy of the application to determine if they have any interest in it and if they want to raise any issues. So in order to probate a will or apply for administration in the Northwest Territories, the deceased person on the date of death must have been a resident in the Northwest Territories or had property in the Northwest Territories. So they can have passed away elsewhere, like if they were on medical travel and they passed away in Alberta or Edmonton, but they were ordinarily resident in the Northwest Territories, their estate would still be administered here. But if they had moved away to BC and were living there for the past 5 years, and they don't have any property in the Northwest Territories, then you would apply to administer the estate in British Columbia. But you could still apply to administer the estate up here if they own property in the Northwest Territories and were living in Alberta, BC, or wherever else. Applying for probate and administration is a really important step because most institutions will not deal with you or release any money to you before they see that document. So usually financial institutions will deny you any communications and access to funds. The pension companies might not provide you a check or further information. Employers might not be willing to talk to you. And the land titles office will definitely deny any transfer of real estate before they see that court grant of probate or administration. You also will not be able to transfer any vehicles over that are in that deceased person's name because the DMV won't allow it unless you show that document. If an estate is under $35,000, you might not need to go through the notice and apply for a grant. There is a lesser and easier process, a less complicated process. So it's really important to understand what the assets of debts of the estate are and determine if they're under $35,000 or more than that. If they're less than that, the court process is a bit more simplified, but if it's more than that, then notice is required and the court process can be a bit more complicated. The estate administration rules apply. All the forms for you to become the estate administrator or executor are available online, but they can be complicated. And usually most people hire a lawyer at this step. You also will need to pay a court filing fee when you file for probate. So that filing fee can range from $30 to $435. It's actually pretty low compared to some other jurisdictions. In Ontario, for example, it's much higher. So usually this is where people end up hiring me. And that process is basically, they pay my retainer fee, sign my retainer document, complete an intake form about the deceased person, who their family members are, what their assets are, what their debts are, who the possible beneficiaries might be. They provide me with the death certificate and the will if there is one. And then I prepare the court documents for them. And prepare any applications, affidavits, etc. I serve them on the beneficiaries, file them in court, and then we get the grant. Once that grant is given, then the executor and administrator is able to handle the estate. You may also need to advertise for creditors because you might not be aware of who this deceased person owed money to. So advertising for creditors is optional in the Northwest Territories. There is no obligation to advertise, but if you are not sure that if there are any outstanding creditors, it may be helpful and a way to avoid personal liability. You usually require 2 ad runs in the Yellowknife or NSSL News North, and there is specific wording that you have to use. So I believe it costs around $500 to run these 2 ads, but it might be really important for you to do that to avoid any personal liability. So before you can give the money to any beneficiaries, you have to ensure that the debts are paid and are settled before they can receive any of that money. Oh, sorry, I'm not sure what happened. So the administrator is not personally liable for paying the estate debt, and the money should come from the estate. But the administrator could be liable personally for those debts if those debts were incurred while they were administering the estate. So if there aren't enough assets in the estate to pay off the debts, then items might need to be sold. So if a person has, a credit card that has $10,000 owing on it, but then they have a car that has 10,000, that is worth $10,000 with no debt, the car might need to be sold to pay off that credit card company first. So the executor isn't personally responsible for paying those debts, but if they incur debts while administering the estate, they could be liable. So if the executor goes ahead and makes a distribution to a beneficiary before they determine and pay these debts, then the executor could be personally liable and have to pay for that money that they didn't pay the debtor, but paid to a beneficiary. So that's why it's really important to determine what the debts of the estate are, so that you can pay the debts accordingly. These debts, for example, are medical expenses, funeral expenses, mortgages, lease payments, property taxes, telephone bills, utility bills, internet bills, credit cards, lines of credits, subscriptions like Spotify and Netflix, income tax that's owing, business debts. It can also include child and spousal support, and it can include any personal debt as well. There is also a priority in which you should pay off these debtors. Usually, after the funeral home expenses are paid, the Canada Revenue Agency is generally the first person that has to be paid, then any secured creditors, and then any unsecured creditors. So if the estate has a lot of debt, it is really important for you to consult with a lawyer and an accountant or a tax expert to determine who should be paid first, because there might not be enough money to pay everybody that's owed. You can't just pick and choose who you want to pay first. There is an order which you have to pay people. It's also really important to file the taxes for the deceased person. So you will be responsible for collecting the T4s, the T5s, and filing any income tax returns with the Canada Revenue Agency. That might involve filing any overdue returns for previous years. And it also will involve you filing an estate tax return once you have done all the taxes. You might be required to file that final tax return for each year or part of the year that the estate is under administration. So if it takes you 4 years after the deceased person has passed to administer the estate, you might still have to file taxes for all 4 of those years. You'll probably need to seek advice from a professional for tax advice on preparing and filing those estate income tax documents. If the individual also owned property in other jurisdictions like the United States, there also might be tax payable to the IRS or whatever jurisdiction they lived and owned property in. The potential tax liabilities can be significant with respect to taxes, and that's why it's really important that you resolve the tax matters and receive something called a clearance certificate from the CRA before you distribute any money to the beneficiaries. If you fail to get the clearance certificate from the CRA, you could be personally responsible for paying some of those outstanding income tax obligations. So really important for you to get the clearance certificate before you even think about paying off other creditors and think about paying money to any beneficiaries, including yourself. So again, really important to work with an accountant or tax expert to determine what taxes are owing, because there also might be capital gains taxes if the person owned any capital property, like a second property that they rented out, for example, or a business. This is because the Income Tax Act says that everybody has disposed of their assets immediately before their death at fair market value. So if an asset increased in value since it was acquired, it might be subject to tax in the last year. There might be rollovers and things available if it was your spouse that passed away, but it's really hard to talk about that in the abstract. And again, you should get some advice on that. But I guess what I'm trying to say is don't give any money out until you've done the taxes, until you've obtained the clearance certificate, and until you've paid other creditors. Okay, so now you've done all that, you've collected the assets, you've got the grant of probate, you've determined who is owed money, you've done the taxes, you've paid everything. Now it's finally time for you to distribute the assets to the people who are entitled to it. It's recommended that you wait to distribute the money. So usually you should wait around 6 months after the grant and the order from the court is made to distribute any money. This is to allow anybody to bring forward any claims under the Family Law Act or the Dependency Law, Dependents Relief Act. So there's some statute of limitations here, but generally 6 months is a good guidance, but your individual circumstances might vary. So again, it's best to consult with a lawyer on your specific case, but 6 months is a good rule of thumb to start with. Before you distribute any assets, you should really ask yourself, main questions. Have you gotten that court order, the grant been obtained? Have all the assets been gathered? Have the debts and claims been settled? And have the limitation periods for spousal and dependent supports passed? And have the returns been filed for tax purposes and a clearance certificate obtained? If there's a will, you should distribute the assets that are remaining according to the terms of the will. So there is also an order in which you can distribute. You have to give the money to the specific beneficiaries first, or the specific items to the specific beneficiaries, and then to the residuary beneficiaries. So there is an order in which you have to pay people. So maybe an estate doesn't have enough money to pay and account for all the wishes that were contained in the will. There is a specific order that you have to pay those monies to those specific beneficiaries, and you should consult a lawyer. If there isn't a will, then of course you need to consult the Intestate Succession Act, because again, there is an order for who is to be paid and how much they are to be paid, depending on how much is in the estate. So after you have done the final distribution, the administrator or executor will need to prepare and submit a full accounting of the estate to the beneficiaries. It can be through the courts if there is dispute as to how it was distributed, but usually most people are agreeable to how the estate is distributed. And this really comes down to how well you kept your records and how well you kept your beneficiaries informed. You should get a signed release from the beneficiaries after you give them any type of payment, whether it's an interim payment or a final payment. This is to cover yourself. You can finally close the estate account after you have obtained those releases from those beneficiaries. So you can close the estate account at the bank, for example. You might need to hire a real estate lawyer to transfer the home to beneficiaries as well. So just keep that in mind when you're trying to give, a house to the beneficiary that's listed under the will. You might need to hire a real estate lawyer in addition to the lawyer you already hired for probate to do that transfer for you. You could also do this through your own band or self-government if that government allows that to happen, if it's a leasehold interest. So I know that it can be difficult to distribute some of the assets that are on leasehold lands, especially if there's no will or a will that is clear. So it's really important, that you get a will as well, but that you consult with somebody before you distribute any items or any money to other individuals, because as you can see, there's a specific order. Okay, so I just want to go over some of the responsibilities that you hold as an executor or an administrator of an estate, because the job you do is a really big one and it's not just ordinary. The most important thing to remember is that when you are the executor or the administrator, you have a fiduciary duty to the beneficiaries. You have a fiduciary duty to the estate. You're held to a very high standard. And really the essence of being a fiduciary is acting for the benefit of another person and putting their interests first. The estate doesn't belong to the executor, even if the executor is a beneficiary. The executor holds the estate in trust for the beneficiaries. So it's a really high standard. You have to act honestly, prudently, and in good faith. You have to exercise really good care, and you must be more careful than you would be with your own property, because it's not your own property, it's the property of the estate that you're holding for the benefit of other people. You have to keep really good records and account properly. This will avoid any disputes with the beneficiaries and will also just cover you from any personal liability that you have when you become the administrator or executor. You should be careful to avoid any conflicts of interest, and you have to ensure that the beneficiary's best interests come first. You have a duty of loyalty to the beneficiaries, and there's a general prohibition on self-dealing and profiting or gaining or having a financial advantage from the estate or trust. So unless it's explicitly permitted in the will or an agreement of some kind, an executor or trustee can't purchase or borrow from or loan the estate or trust any money. The office of the executor or the trustee can't be used for any personal reward. You're really accountable to somebody else. And so you might be a beneficiary with your siblings, for example. You have to be fair amongst all of you. You can't take a huge benefit just for yourself because you're the executor. Sorry, I just want to quickly go back to keeping good records and accounting properly. As a fiduciary, you have an obligation to account to the beneficiaries, and only if they have full information can they be in a position to protect their interests. So to be able to have that, the law requires the executors and trustees to maintain good records and produce any accounts on reasonable notice. So if you take on the role to be the executor or administrator, it's really key to keep good records right from the beginning, such as keeping receipts, notices, disbursements, invoices, checks, vouchers, etc. Because if the beneficiaries aren't happy, they might require accounts to be reviewed by the courts in something called passing of accounts, which can be a costly and time-consuming process for the executor. As the executor or administrator, you also have to treat the beneficiaries equally and fairly. This is called the even-handed rule. And a fiduciary has to treat everybody with an even hand unless otherwise directed by the will. This can be a challenge, especially when a family member is the executor or the trustee. But you do have to treat all the beneficiaries equitably, and you can't play favorites. There has to be a certain professional detachment and neutrality in carrying out your job as the executor or administrator. You have to ensure that all communications to beneficiaries are equivalent and at the same time, so that everyone is on an equal footing. And when you're making distributions, you have to have an equal footing with that. You can't, if a beneficiary or the other person tries to take an upper hand, it's important for the executor or trustee to ensure everyone receives fair treatment. For example, distributing a parent's personal and household effects amongst their children is in an equitable way, especially when one of the siblings might try to overreach. So it's really up to you to kind of keep the peace and take an even hand rule and approach when you're dealing with beneficiaries. You can and should also seek professional advice where appropriate. So you can hire a lawyer, you can hire a tax expert, you can hire accountants to help you fulfill your obligations. And oftentimes people do, but because estates can be complex and can touch on a wide range of complex issues and subjects. So it's really appropriate for you to be able to reach out to professional, but you can't delegate all your authority as the executor. When you do hire these professionals, just so you know, the cost of that professional advice, as long as it's reasonable, will be covered by the estate, as long as the estate has money and are not something that you as the executor have to pay personally. So if you hire a lawyer to help you with probate, that money should come from the estate, not from you personally. In cases where professionals are used to complete tasks that the executor is normally expected to do, then the executor compensation, which we'll talk about next, will likely be deducted from that amount. So you can't delegate your authority to make decisions regarding the estate or trust property to someone else unless it's permitted by the will or by a court order. So while simple administrative tasks can be delegated, the executor or administrator still has that fiduciary duty to oversee everything. They can't delegate their key decisions, but they can delegate some of the administrative tasks that are involved. So ultimately, the executor or the administrator is the person primarily responsible for overseeing the administration of the estate, like strict requirement to do so in a very ethical type of way. They have a fiduciary duty, which is a very high standard. If you don't manage the estate properly and you kind of neglect some of this duty and responsibility, you could be personally liable for mismanaging the estate. So some common issues that arise when a person is administering an estate is that they fail to notify the creditors. So there's debt owing and they've now paid the beneficiaries. And so they might have to pay those debtors personally if they can't go back and collect that money from the beneficiaries. They might not have a complete inventory of all the assets and the debts. So maybe they deal with some of it, but then they forget to deal with the house or they forget to deal with the cabin and the lease on that. Another common pitfall is that they mix their own estate money and their personal funds and don't keep good records. So if you needed to, get the death certificate and you paid the $22 fee for that out of your own account, you need to ensure that you keep the receipt because now you've mixed your estate and personal funds. So if you're going to try to claim that as an expense that should be paid back to you from the estate, you need to have good accounting. But it's generally best practice to avoid mixing the estate and your personal funds. Another common pitfall is that people distribute too early. So they might give the beneficiaries, $1,000 here, $2,000 there to help them out before realizing or dealing with the taxes that the estate might have to pay to the CRA. And the major pitfall, I would say, is poor record keeping. You do have to be really organized when you're the executor or administrator of an estate so that you can dispense with your fiduciary obligation properly. So we know that this is a really big job, and generally executors are entitled to compensation. Compensation is what is fair and reasonable unless it's really specified in the will. Compensation is owed by the estate, so there might not be enough money in the estate. But if there is, an executor is entitled to, receive some sort of money for the demanding effort and skill and attention to detail that's required with being an administrator or executor. Executors aren't expected to work for free, and unless there's something specified in a will, they're entitled to fair and reasonable compensation. What's fair and reasonable really depends on the estate. and could be from 2 to 5% of the value of the estate. If you agree to pay yourself 5% compensation, but the beneficiaries don't, then that compensation is supervised by the court through the formal passing of accounts. So again, that can be a costly and time-consuming process, so it's best to get the beneficiaries on the same page and get those releases signed. But if they don't agree on what you want to be compensated, then you would have to go through the court process and do a passing of accounts. It's really just a review and approval of the executor's actions, and can involve many different aspects, not just compensation, but it's one of them. So if the matter does go to court because you can't agree on compensation, the courts generally look at what the value of the estate is, the care and responsibility involved in administering the estate, the time that it took you to perform some of your duties, your skill and ability, as well as the success achieved in administering the estate. So in order for you to be a good executor or administrator, it's really important for you to stay organized. It's really important for you to communicate clearly with the beneficiaries. It's important for you to seek advice when needed. To use checklists and resources. I do have a checklist which I can distribute to the attendees here. That is a document that's, a checklist for all the steps that might be required in administering an estate. Not all of it will be applicable to your specific situation, but some of it may be, and may be helpful for you to refer to that. And lastly, be patient. Estates can take time to administer, but not too much time. You do have an obligation to try to deal with the estate within a reasonable period of time, and that's usually 1 year after obtaining the grant of probate or administration. So just keep that in mind if you are the administrator or the executor of the estate. We've covered everything in this presentation. Thank you, everybody, for attending.